case number F&G 2014-1476. Before we begin with the evidence, Ms. Hathaway has filed an emergency motion for reconsideration regarding this court's denial of Tanya Hathaway's motion to dismiss due to lack of subject matter jurisdiction. Ms. Hathaway, I understand that the basis for your motion is that apparently I left the impression, and I want to correct it, that the only basis for my ruling yesterday was on the basis of judicial estoppel. That was not my intention. It's my intention to indicate that after hearing those many hours of evidence that we did yesterday, that in fact the facts support that this court has subject matter jurisdiction, and the venue is in this court. And further, I did reference the judicial estoppel in that the judicial estoppel was also appropriate under the circumstances. So it was not an either or. It was intended to be a ruling on both. Is that clear now?
I don't understand the grounds for it. Because he wasn't a resident, clearly. It was stated he needed to be a resident for 6 months prior to, and he testified himself that he wasn't, Your Honor, and I'm sorry.
Well, I found that he was yesterday, after hearing those many hours, that in fact he was a resident of the state based upon the factual record presented.
Okay. So Your Honor, for the record, I'm going to have to appeal.
You certainly may.
Okay, so I think that should put a stay for today's hearing.
No, ma'am.
Okay.
And you are proceeding.
Your Honor, also for the record, I need to say that I am not prepared. I have a disability that I've said again and again that has not allowed me to have the support that I need, the accommodations that I need. I put out the emergency situations that happened at home. It's not out of disrespect to the court or to any parties, but anything going forward, I would not be allowed or able to properly represent myself. I have over 151 emails that discuss the marital residence that I haven't been able to put together because of my disability and because I need the support and help to be here with me today if this was to go forward. I have 199 correspondences about repairs. I have 249 receipts that aren't included, but also not to mention cash payments to the subs that I have yet to present. I have 31 medical and settlement disclosures that I could show the court, but I'm not able to because I'm disabled and I wasn't able to do it myself due to the emergent circumstances. I have 22 emails on the status of Newberry to prove that. I have 40 emails regarding the deed. I have 89 emails or texts when I'm referencing emails that will clearly show commingling. And I have 15 about reconciliation during the period of time that he claims that we were separated, and after this was filed. It would be an injustice to this party to go forward when I have one appeal that is on the record already for notary fraud, 2 more that are found in the temporary order, and another one that the court doesn't seem to want to consider. And I also have, and it would be an injustice knowing that there's another very legal, valid argument that will be going in front of the appellate court, and the fact that, again, I have over and over again told this court and made my medical records available to them, offered total transparency, to be taken seriously here, that I am not able to properly represent myself. And I'm afraid that if I have to stay and try to do this when I feel strongly it's moot, but not only that, when I don't have the support that I need as a noted disabled woman on my medical records, that it would only put things off further, and it puts me at risk.
Thank you. Your request which I interpret as a request for a stay of this proceeding or a delay of this proceeding, is overruled.
So are you denying me the ability to have the help that I need for a disabled person, Your Honor?
You've had 2 lawyers, and apparently you've let them go.
No, I didn't let them go. They both applied for withdrawals.
One did, and then one, Mr. Vaughn, there was an act request before this court, which he said that you had fired him.
That was the second time around. I had no choice but to fire him.
Yes, so you fired your lawyer.
I didn't have the money to pay for him.
And then I had, we held an appropriate pretrial.
To me of, I'd like to put my hands on that pleading. You have all the pleadings here, right? Somewhere. Okay. So it means I have a copy of all those pleadings?
I don't believe they're in those binders. Those are our evidence binders.
Okay.
I know this might be an opportune time to ask the court to take judicial notice that we have 6 banker's boxes worth of documents that we had to bring to today's file, not including the binder exhibits. I would like judicial notice of that.
We'll take judicial notice. The court.
Like I can look for this pleading sheet looking for.
Well, we just need to move on.
Oh, this is part of the reason, Your Honor, why I told you I'm not capable of doing this myself, and that I'm disabled and I have limitations.
Also stated that throughout the pendency of the order, you were each to pay your own living expenses.
Yes.
And that would have included the electricity?
Yes.
All right. If you will turn, please.
Excuse me, Your Honor, I need to go. I need to get my breathing under order. Excuse me.
I've got an idea. Continue to drag out. And I've got an offer for you. Do you want to hear it? Or do you want me to wait?
I'm having a panic attack. The only way to stop it now is to take meds that'll knock me out, and then I can't even be there.
Okay, well, another way to stop it would be for me to eat your offer and see if you like it. I have panic attacks too, I get it.
Not you, and you're not me. You just don't get it. It's not a game. It's so far from a game. I want it so hard.
I've got an idea for that.
I don't even know if I can talk.
You don't have to. Just listen and think about it. My idea is if you get a lien on the house with an amount, I think we've all agreed that $25,000 is at least what you put into it, and I think that we agree that if we're to sell the property, there'll be at least that much, amount.
Oh, Rashad, you're so fall out of the ballpark. Yet you're paying from his property grown so much, and his share, don't get it from mine. He did this, and you know it. He's a catalyst. He's a flippin' liar. You know it.
I am not getting paid, Tanya. I can't do this case. I want it over.
I want it over because I can't breathe, and because I can't live, and I can't live with him trying to take everything through lies, perjury. You know as well as I know it's not fair. You know as I know that the law still doesn't stand on his side.
Well, let the judge make that decision.
Let the appellate
appellate court make the
To say there's any way we can figure out to get this over to us.
Hey, you know, Michelle, you just accused me of extorting you.
Well, that letter.
No. It was a settlement offering.
Okay.
That's not extortion. You're not my friend.
I'm not trying to be a friend of one.
You want this case over at everybody's cost, but at my cost, everybody else being liars, being fraudulent to the court. You know it.
No, is there anything what would it take to get this done?
25,000. You're joking. You're joking.
That's our first offer. Tell me.
Well, no. Last and final. How about that? Winston knows how that is. Biggest and best. Look, I didn't want to be in that big place by myself. I didn't ask for that.
I'm sorry. I wanted to see if there's any way you can
I would love to. I need to take a medication to stop my panic attack right now. I can't take it and be sound-minded there. Don't you get it? The judge doesn't get it. He's denied me. It's called a disability.
We're back on the record. We're taking a short break. Ms. Hathaway has returned. Ms. Hughes, you may proceed.
Your Honor, I need to interrupt.
Pardon me?
I'm having a panic attack, and if I don't take medication, I'm going to have to go to the hospital. And if I take medication, I won't be able to stay awake and think clearly.
How much time do you need?
I don't know. Read my records. I have given you my records. I told you I need accommodations. This is not a joke.
Well, I'm not. There is no joke now. What accommodation are you requesting today?
The same accommodation I requested you all along before. That you... I don't care if you denied me or not. I just can't afford to be denied that. I am...
Yes, ma'am. Okay. Ms. Hughes?
Judge, objection to admitting all exhibits that have been presented by Ms. Hathaway, that are here before the court. All of our exhibits have already been admitted.
I can't try this case myself. I got tons of exhibits that aren't here. I can't. My thought process, my ADD doesn't allow me to do it. That is real, and my panic attacks.
Judge, that's my proposition.
I understand. So, Ms. Hughes has offered to allow all of your exhibits that have been submitted in this binder to be admitted. And I'll...
They submitted in what binder? The binder that she selectively included for me?
No, ma'am. These are the exhibits that were more than exhibits. They're all the documents that were provided by your prior counsel to Ms. Hughes.
And my prior counsel didn't give me squat. I don't know what he's done. And that's on the record. I can't defend myself here.
You were provided with all of those documents on Monday. Is that right?
Yes.
In the binders. So we had an opportunity, and you obviously you were in court yesterday. Last night you had an opportunity to prepare.
No, my disability does not allow me an opportunity to prepare this magnitude.
Last night you prepared a 12-page...
No, I didn't. I got help with it.
Are you saying you have legal counsel that's helping?
No, I don't have legal counsel that was helping me. I had a friend help me with it after we talked, and he emailed it to me. I'm not competent and capable to do that myself.
Well, we're going to proceed with this trial.
I'm not able to do it without stopping my panic attack, or I'm going to have to go to the hospital or take medication that disallows me to be competent for trial. And I want to be competent for trial.
We're going to take a 15-minute recess so you can collect yourself.
I need help.
And I'm going to admit all of your exhibits that are contained in the binder.
I don't know what to do with them. I am at a disadvantage. I am disabled and I'm having a fit.
Okay, Ms. Hathaway, I need to give you this. This is just the judge wanting you to back up to the courtroom.
Judge what?
Wants you back up to the courtroom. All right.
That length of time is hard on you personally.
Well,
Now, for a 6-month marriage, the cost and time has been exorbitant. There were no commingled assets. We didn't have joint bank accounts. We didn't have joint savings accounts. The property was clear. The property in her name remained in her name. The property in my name remained in my name. And there was no reason for this case to have gone on this long. Absolutely none.
Okay, with respect to the Philbrook property specifically, how have you been damaged?
Well, I don't know the condition of the property now. I don't know what has been left undone. I know that she has told me there have been 3 or 4 floods in the basement. She's changed the drainage on it, and obviously it's causing a problem. She has changed the character of the property from going towards being a single-family house to being a boarding house or some type of rental.
Okay, now what is your testimony regarding an amount, if you could actually have an amount of damages that this divorce has cost you, including your lost employment?
Well, the lost employment's close to $60,000 or $70,000 because of my salary was $50,000, and
Was there a claim in the pretrial conference order for some kind of lost income?
Your Honor, most of this is actually rebuttal, so I could save it.
Right, you mentioned loss of employment. Isn't it true that you posted on your Facebook page about 3 ladies that you're going to be on Dr. Phil show with?
yes.
Okay. And don't you have a letter from ORU that says because you did that, that you're relinquishing, that you were losing employment?
Objection vague.
Okay.
Overruled on vague.
My understanding was I was terminated because I appeared on the Dr. Phil show with you.
The letter that I saw, okay. Did you receive a letter from ORU that stated that you had posted that you were going to be on the Dr. Phil show and that's why they terminated you, or something similar to that? Wasn't even referencing necessarily that you...
I think we just said that he lost his job, and we're not really making any claims right now about why. If he wants to go down this road, I suppose.
Can you tell me how that will help me make a determination about the division of property today?
Well, because he brings up loss of employment, and I'm trying to get blamed. They're trying to blame me for it.
But he's not making a claim for any lost income. And I've already granted divorce on the grounds of incompatibility.